Allegations of will tampering within the AmaZulu royal household has put a spotlight on many things. Some family members say that the late King Goodwill Zwelithini's will was interfered with, and the king's first wife, as Tuba mentioned, Queen Sibongile Dlamini, has submitted urgent court papers. This in a bid to inherit 50% of the estate. Now, the king's will was drafted back in 2016. So let's look at the importance of drafting a will now and what makes one valid. It's the planning lawyer, that's Mervin Messias, joins me now to educate us on this. And thank you so much, Mr. Messias, on this rather important conversation at this time. I suppose before we get into, some of the nitty-gritties and challenges that have to do with a will, what is the overall importance of one drafting a will while they're still alive?
Good morning. Well, there are three main reasons why one would draft a will. One is a protective reason, in other words, to ensure that there's no allegation of forgery. This particular issue is now before the court. And now the other thing is one of evidentiary value. So in other words, to prove that there was a will, which is a unilateral voluntary declaration of one's wishes for when they have passed. And the other one is a cautionary one, which is quite important because it warns you how important the document is, and you must think twice about what you're signing.
Right. So obviously that is a valid will that we're talking about, a legally recognized one. In this instance, where the AmaZulu, princesses from the first Queen Sibongile, in as far as their court papers indicate, they say that they believe, they're of the perception that the will might be forged. Their father's will might be forged. Now, how would you then differentiate between a forged will and a legal and a valid will?
Well, the first thing is that prima facie, if the will appears to be valid, in other words, it's been signed correctly by the testate or testatrix, the man or the lady, and the witnesses, and a commission of oaths if necessary, then on the face of it, prima facie, as it were, the will is valid. And the onus is on the person who challenges the will to prove on a balance of probabilities that the will is not valid because, for example, signatures have been forged.
And I'm glad you bring the issue of our own signatures, because I read in reports that the princesses also believe that their father's signature was forged, saying they had to employ a handwriting expert to sort of detect, to help them rather analyze whether the signature is forged or not. Now, in this instance, where we're seeing this case rather being presented in the High Court in Pietermaritzburg, how long do you think it would take until perhaps we see an outcome, but also what are some of the, some of the pointers with which the lawyers would have to make mention of in terms of pointing out if these indeed are issues in the will, that it's forged and it's not legally binding?
Well, the first thing is that the witnesses must be challenged. Did they actually see the king sign, and were the signatures of the witnesses valid? Were they forged as well? If that's not the case, then the onus of proof, as I say, is on the person challenging the will. And they will have to show that the will was not signed by him with a handwriting expert, but I presume that will also be challenged by the other party with their own handwriting expert. So this is going to be quite a conflict. Now, my opinion, I'm a notary public, and in my opinion, with such an important dignitary as the king was, the will should have been signed in front of a notary public as well, and there should have been some evidence of his mental capacity to understand the nature and effect of the will, just to make sure that there'd be no challenge. So if the will was signed before a notary, in its proper format, there would be no challenge about forgery.
All right, we'll leave it there, but thank you so much for bringing clarity. It's the planning lawyer, that's Mervin Messias.